Good evening. I'm John Marion. I'm Executive Director of Common Cause Rhode Island. I want to welcome you tonight to our third Demystifying Democracy event of 2025. We're calling it Understanding the Limits of Executive Power. Before we get started, I want to mention we're making Spanish interpretation available tonight. So I'm going to turn it over to Patty from Be More Interpretation now, and she's going to let you know how you can turn on that feature if you want to use it. So Patty, take it away.
Sure. Thank you, John. Okay, so we will be offering simultaneous interpretation this evening. This means that I will be in a separate audio channel, simultaneously interpreting into Spanish what everybody will be speaking in English. So as you can see in the instructions in the chat, the interpretation has not been turned on yet. As soon as Alicia turns it on, you will see a globe at the bottom of your screen. If you don't see a globe, you will see it under the three dots that say more. It's important that everybody chooses a channel, even if you're just listening in English. This just makes the audio better. And if for any reason I need to come back into the English channel and interpret something in Spanish, this way everybody will be able to hear me. So once that is turned on, Alicia will let you know, and please go ahead and choose the English channel. Ahora voy a hablar en español. Estamos ofreciendo interpretación en español simultánea. En el momento que Alicia aprenda la interpretación, ustedes van a ver un globo abajo en su pantalla y van a poder seleccionar el lenguaje de español para poder escuchar en español la interpretación simultáneamente. And just a quick reminder to everybody who's speaking, I will be speaking 2 or 3 seconds behind you. You do not need to pause because I will be in another channel, but it is important to just speak at a moderate pace so I can keep up with you. Thank you so much. Okay, and Alicia can turn that on.
Great. Thank you, Patty. Thank you for turning that on, Alicia. So as Patty said, you'll need to go down to the globe at the bottom and choose a channel, even if you're choosing English. We also have closed captioning available this evening. So that is next to the globe at the bottom of your screen. So if you'd like to turn on the closed captions, you can do that by selecting the CC button at the bottom of your screen. We're grateful tonight. Our event is co-sponsored with the Rhode Island affiliate of the American Civil Liberties Union. And so I'm going to turn it over to Zoe Chikoyan from the ACLU of Rhode Island, who's going to say hello.
Hello, thank you so much, John. As stated, I'm Zoe Chikoyan. I'm the Communications Associate for the ACLU of Rhode Island, and we are very happy to be co-sponsoring this event. To very briefly introduce our organization, we're the Rhode Island affiliate of the American Civil Liberties Union. Our state affiliate was founded over 65 years ago, and we work every day to protect civil liberties, which are the rights and freedoms guaranteed by our Constitution. This covers a lot of issue areas, from freedom of speech, privacy, reproductive freedom, immigrants' rights, and far beyond, the rights that really affect every single Rhode Islander in some shape and form. We do our work by taking action in the courts, lobbying in the State House, and sharing public education materials. We primarily work only in Rhode Island, but you'll get to hear this evening from one of our cooperating attorneys, Lynette Labinger, who will share about some cases we've taken on with our national office to challenge some federal executive orders. Yeah, thank you so much. I'm very excited to hear what the panel has to say.
Great. Thank you, Zoe. And thanks again to the ACLU. So Common Cause has been hosting and co-hosting these events since 2017. We've done more than a dozen topics. You can find them all at our website, demystifyingdemocracy.org. But this is the first time we've ever tried to look at the federal government. Typically, we focused on state and local government in Rhode Island. The idea came from a board member of Common Cause Rhode Island when she asked at a board meeting, what's an executive order? So tonight we're going to try to answer that question and other questions about what's happening in Rhode Island, or excuse me, in Washington, D.C., in courtrooms around the country, including courtrooms right here in Rhode Island. We have a great and distinguished set of panelists who I'll introduce in a minute. Before I do that, one housekeeping item, we are going to take questions from the audience. We're going to break in about 40 minutes for that. So if you have a question, please use the Q&A feature at the bottom of your screen, and Alicia is going to collect them and feed them to me, and I'll feed them to the panelists. We also got some of your questions in advance for when you registered. I've sprinkled those in to the questions I'm going to ask the panelists. So many of you will have your questions answered that you submitted when you registered. So now on to the panelists. Our first panelist, Professor Diana Hassel, teaches constitutional law, civil rights, critical race theory, and race and the law. She writes in the areas of civil rights, litigation, due process, and integrating issues of racial justice into the law school curriculum. She's one of the designers of the course Race and Foundations of American Law and is co-author with Monica Teixeira de Souza and Nicole Disluski of the casebook Race and the Foundation of American Law. Professor Hassel has been a professor of law at Roger Williams University School of Law since 1995. She has her BA from Mount Holyoke College and JD from Rutgers Law School in Newark. Thank you for joining us. Next, we have Charles Hunt, who's an associate professor of political science at Boise State University's School of Public Service. He's also the author of the book Home Field Advantage, which is not about football, which assesses the local roots that members of Congress do or do not have in the communities they represent and the representational and electoral consequences of these roots. He also co-authors the textbook Congress Explained. He conducts research broadly on Congress, elections, representation, and political geography that has appeared in academic journals like the Journal of Politics, Legislative Studies Quarterly, and American Politics Research. His research has also been featured in journalistic outlets including the Washington Post, CNN, USA Today, U.S. News and World Reports, and The Conversation. Charlie received his bachelor's degree in political science from Brown. He's a native Rhode Islander before serving as director of public affairs for a political consulting group in Providence. He then went on to get his doctorate in government and politics from the University of Maryland, College Park in 2019. Thanks for joining us. Lynette Labinger is a longtime civil rights litigator in Rhode Island. After a 2-year clerkship with federal judge Raymond Patine, she joined the law firm founded by Milton Stanzler. Stanzler was instrumental in creation of the Rhode Island chapter of the American Civil Liberties Union. She continues her advocacy championing constitutional and civil rights litigation throughout her years of private practice, first with Stanzler's firm, then a 35-year association with her partner, John M. Roney, and since 2018, limiting her practice to cases sponsored by the ACLU of Rhode Island. She's a longtime cooperating attorney for the ACLU of Rhode Island, which has twice honored her with its Civil Libertarian of the Year award. She's litigated many high-profile civil rights cases in Rhode Island, including cases involving discrimination based on race, gender, age, and disability, reproductive rights, and First Amendment rights, representing a teenager and vindicating her First Amendment right not to have a religious display in her high school, and representing a prison inmate and vindicating his right to practice his religion in prison. So thank you, Lynette, for joining us. Finally, we have Miriam Weisenbaum. She joined Amato DeLuca in 1995 to establish the Providence law firm of DeLuca and Weisenbaum. Ms. Weisenbaum is a trial lawyer whose practice in civil litigation includes representation of people injured by medical errors and negligence, defective products, government and police abuse, and other civil rights violations. From 2020 to 2024, she was chief of the civil division of the Office of the Rhode Island Attorney General, brought in to build out the AG's public protection unit, or work, excuse me. Ms. Weisenbaum attended Simon's Rock of Bard College, where she received a BA degree. After working as a community organizer, she earned a JD at Temple University in 1986. In 2016, she and her law partner, Amato DeLuca, founded a nonprofit public interest law center, the Rhode Island Center for Justice. Since its founding, the Center for Justice has been fulfilling its mission to protect legal rights and ensure justice for vulnerable individuals, families, and communities through partnership with community advocates, while training and mentoring future public interest lawyers through an innovative fellowship program. And we're an awardee of Common Cause for some litigation just 2 years ago. So thank you all for joining us. I'll get started with the questions, and I'm going to start with Professor Hassel and ask you that question. You know, what is an executive order, and do they have the power of law?
Well, yeah, thank you. Thank you for joining us, everyone. And I'm excited to talk about these ideas. executive order is much less than President Trump seems to think it is. Executive order is essentially is an ability, he can direct the executive branch to do things that is within their purview to do. So of course that raises the question of what is it that the executive branch has the power to do? And there are certain enumerated powers in the Constitution that belong to the president, such as commander-in-chief and pardoning and a few others. But basically, the president's job is to execute the laws that have been passed by Congress. So he's not lawmaking, he is directing how these laws should be executed. And often what's happening is there's a tension between the president and Congress. The president wants to do something, Congress isn't willing to give him the authority to do that. So he's trying to expand his authority, take a statute that exists and try to bend it to some other meaning and say, oh, look, I really do have the authority to do this. And often presidents are stopped from doing that because there are limits on, they can only execute the laws that exist and they have to be an appropriate interpretation of those laws. In addition, they cannot issue any executive order which violates the Constitution. For example, telling the executive branch to do something that would violate the First Amendment or violate free speech, such as telling universities what they can teach or telling law firms who their clients can be. So they are limited by what is their actual power that's been given to them by Congress, and then they're limited by other constraints of the Constitution. None of these executive orders can violate the rights that are enshrined in the Constitution. So many of the most recent executive orders are problematic for both or either one of those reasons. Either the president is trying to assert a power that he doesn't have, such as let's declare what the 14th Amendment means and what birthright citizenship means. That's not within his executive power. Or he's interpreting a statute in a way that is not plausible, or he's doing something else that violates some other right, some other individual right. So he can put those things out, but there are many limits on what he can actually do.
Thank you for answering the foundational question here. Next, I'm going to turn to Professor Hunt and ask, as a Congress scholar, that's sort of setting up the question here, why do we see so much executive action right now?
Yeah, I mean, I think the main reason, and it's an obvious reason, but it's obvious because it's true, is that Congress is essentially passing the buck. To Diana's point, Congress is supposed to have the power of the purse to make a budget, as they are trying to do right now. Congress has the main lawmaking power, that the president's job was, as Diana said, to execute the will of Congress as they made it known. But we've had this period of time in which Congress is so polarized and having such a great deal of difficulty actually getting anything done of major substance through traditional means of lawmaking, that the president, and by the way, this did not start with President Trump. He's certainly exceptional and an outlier here in these first 100 or so days. But the last several presidents, Democrat and Republican, have sort of precipitously increased the amount of power they are taking for themselves in the absence of a Congress that is willing to make major new legislation and make their will known to the president. And so that's really the main reason I've been seeing. And so I think, with Congress and with the partisanship that's set in there, it's made it really difficult for them, really, whether they're in the same party as the president or not, to really challenge the president in any way, shape, or form, because they're not politically incentivized to do so.
Thank you. Next, we're going to turn to Lynette, and you're sort of in the trenches in dealing with this on behalf of the ACLU in Rhode Island. So you've challenged 2 executive actions, which is highlighting that word because one is an executive order and one is a presidential proclamation. The executive order is on promoting gender ideology, and the executive action that is a presidential proclamation is invoking the Alien Enemies Act. First, can you briefly explain the difference between an order and a proclamation, and then describe how you're challenging both types of those actions and who you're representing?
So, I mean, the executive order, as Professor Hassel said, is designed to instruct the executive agencies that the president administers as to how to fulfill their responsibilities. And that's all of those executive orders are directed to federal agencies to do something or not do something. A lot of executive orders on the first day of a lot of different presidential switches of administration from one party to the other are orders that revoke the last president's executive orders that are still standing. So that's not uncommon. A proclamation is directed not to the agencies, but to the general public. And they can be, sort of like common or everyday, like, proclaiming something National Something Month, or funereal, if there's a congressional authorization for certain holidays or memorials besides the congressionally established holidays, like recognizing President Carter's death and everything closes down. That's pursuant to a presidential proclamation. One of the most important ones was called the Emancipation Proclamation. And that was a presidential proclamation, and it basically instructed that all enslaved persons in the Confederate States would now be free. And of course, the Confederate States weren't paying any attention at that time to the president because they were at war. So it was important, but it didn't have a direct impact on as the force of law in those locations. So they can run from very commonplace things to very significant things. In our case that we have pending, there's a law called the Alien Enemies Act, which I'm sure everybody's familiar with because it was passed in 1798. And before now, it was invoked 3 times, each during a time of the War of 1812, World War I, and World War II. And the law, so some proclamations are just a presidential statement that that's basically expressing the view of the president. Others, if they are acting upon a congressional authority, they can have the force of law. So you can think of a president proclaiming a certain location a disaster area. There's a congressional authority, and that triggers the opening up of federal monies, federal support. So it's important that the president declare a certain place a disaster area. So the Alien Enemies Act has very specific provisions that include the removal, and removal is the legal term of art for deportation, or involuntary deportation of non-citizen aliens who, under certain circumstances during times of war, a military invasion, and it's invoked by presidential proclamation. So that gives it the force of law, except that it has to be based on the underlying existence of a declared war or an enemy incursion, military incursion into the country. And even then, it provides for due process protections for the individuals targeted to get their affairs together before they're sent out of the country. So President Trump invoked the Alien Enemies Act and declared that the people who are gang members of, and I'm going to mispronounce the name, Tren de Agua in Venezuela met that standard. and started involuntarily removing them and sending them, some of them, to El Salvador to be in prison without any kind of process at all. Our plaintiff, GMG, that's obviously a pseudonym, was taken into custody, and we have sued to prevent the Alien Enemies Act being applied to him, generally on 3 grounds. One, that this is not a proper invocation of the Alien Enemies Act. So we're challenging the validity of the proclamation because the gang is not a foreign government or an invading military. And also because they haven't set up processes to effectuate the removal with due process and opportunity to be heard. And there are other laws in the United States that prohibit torture and sending this individual or similar individuals to a place where it's known that they will not be protected from torture by being sent to immediately to basically a gulag is also violative of our laws. And then finally, we're challenging that this individual is not properly designated as a member of this gang. Now, we filed the case. The court issued an order requiring the government to give notice, at least now 72 hours notice before they move him at all from the jurisdiction of Rhode Island, and that's where it sits. So there are other cases throughout the country where other courts have already found that, as we've argued here, that this proclamation doesn't validly invoke the Alien Enemies Act, and those are probably going to make their way up the court ladder to the Supreme Court eventually. The other case, which challenges an executive order, we sued the National Endowment for the Arts concerning the, we call it for shorthand, the Gender Ideology Executive Order, which is long version is defending women from gender ideology, extremism, and restoring biological truth to the federal government. It has many parts. It basically proclaims that there are only 2 sexes and that federal funds shall not be used to promote gender ideology. Again, this one's directed at federal agencies. Each agency shall assess grant conditions and grantee preferences and ensure that grant funds do not promote, whatever that means, gender ideology. The NEA, after receiving this executive order, revamped its grant processes to let everyone know that things were going to be judged as to whether they conform to this gender ideology mandate. We've brought a suit for a number of grounds. One that's very important is that when you say you can't promote gender ideology, but otherwise you can take a position that supports this executive order, that's basically picking one side of an issue, and that's called viewpoint discrimination, and that impacts First Amendment. When you're saying only one side of an argument can be heard, that undermines freedom of speech. Also, we've challenged it on the basis that the statute that created the NEA is very specific, both in terms of its language and its legislative history, that Congress said, we are not going to be reviewing and censoring the productions that the grantees want to put on. The only thing we look at is artistic merit and excellence, and not whether we agree with the theme or whatever they're going to put on. And on that basis, we're arguing that that this executive order is contrary to the statute, and therefore the action by the NEA to incorporate it violates what's called the Administrative Procedures Act. Most of these cases throughout the country that are challenging executive orders are at least one if challenge is based on a violation of the Administrative Procedures Act, which governs federal agencies.
Thank you. I mean, thank you both for the explanation and for the work. Miriam, you've started a group called Lawyers Committee for Rhode Island. Can you explain a little bit about what that group is and what that group is doing and plans to do?
Yeah. So, first of all, of course, lawyers are uniquely situated with a professional ethical responsibility to uphold the law. And so the Lawyers Committee for Rhode Island is a group of lawyers who came together with taking on the obligation to protect people, groups, institutions in Rhode Island from illegality visited upon them by the administration. And so we're a group of lawyers who are connected to different communities and engaged in different forms of protection in areas of immigration, these attacks on funding, which I think we're going to talk a little bit more about later, and education right now, but also trying to identify emerging threats so that we as lawyers are prepared to respond to those as well. The reason we started this is because it was clear, obviously before the election, that this, if this were an incoming administration, they had a clear plan to just barge through the limits on executive authority and engage in illegal acts that would hurt people, whether it's illegal detention or punishment for protected speech, targeting based on race, or withholding funding in violation of laws passed by Congress that mandate that funding. And so what we're doing is we're a group of mostly volunteer lawyers. Two of us are paid by my law firm to provide that protection, whether it's know your rights training in the community in the immigration context. We are putting together a habeas task force and have assisted with habeas petitions, which I know we're going to talk about later. But those are targeted at illegal detention. And then a large part of the work is helping nonprofits who receive federal funding or are applying for federal funding, and through these executive orders, which are just, as Professor Hassel described, are really statements by the executive, but through these executive orders that presume to avoid or ignore laws passed by Congress, withdraw funding from nonprofits that really are woven into every part of the civic fabric of Rhode Island. So that's the mission that we have taken on.
And we have a lot of attendees tonight. I don't know if any of them are attorneys. If somebody wanted to volunteer their time, how would they do that?
Well, come on down. We've done attorney trainings, and we're doing more. So we would welcome you. You can email at info@lawyerscommitteeri.org.
Okay, and that's your website, Lawyers Committee.
And that's the website too, lawyerscommitteeri.org.
Great, thank you. So, Professor Hassel, there's a lot of litigation. We heard a little bit about some of it, and a group that's preparing to do additional litigation. Is this normal, like to see all this litigation?
Well, as I mentioned before, and as Professor Hunt mentioned, often these executive orders are issued by presidents because there is some political tension of their not being able to get Congress to pass a statute that would give them the authority to do what they want to do. So, for example, in the past administration, President Biden wanted to do student loan relief, and he relied on a statute that was kind of a little vague. Did he really have the power to do this? but he tried to use that authority given him by Congress to do a lot of undoing of student loan debt. Immediately after he did that, there were lawsuits. I think those lawsuits were brought mostly by states attorneys general who opposed this kind of revocation of the debt, and they won. It went to court, and the court said, no, President, you don't have the authority to do this. So certainly executive orders have been challenged, and as they are often, and this was true of President Obama and the first President Trump in his first administration, they are doing something that they probably can't do. It's probably stretching the limits of what they can do, but they're frustrated because they can't get it done any other way, so they try this. And then a lot of them are challenged. I would say this time around in the second Trump administration, the amount of litigation has exploded. And that is because of what we've been talking about, the sort of overbroad, lawless, reckless way that these executive orders have been issued that have done all kinds of damage, both individually and to individuals and to our structure of government, and the sheer number of them. President Trump has issued over 140 executive orders in the first 100 days of his office, of his being in office. This is hugely more than any other president has done. President Roosevelt is the closest, and he issued, I think, 85 in the first 100 days. So he's done a huge number of them, and he's done them with seemingly no regard for what may or may not be legal. So there's a lot of them out there, and probably 90% of them have a viable legal objection. I don't know how many. I haven't read all the 142, but many of them have really significant legal problems. They were not carefully vetted. They were not attempting to be within the law. They are attempting to challenge the law. And even if these executive orders are someday, the courts someday say, no, you can't do this, the damage in a way has been done just by the fear and the turmoil that has been caused by these executive orders.
Thanks, and thanks for doing that additional research. The numbers are extraordinary. Professor Hunt, I had a question, but we also got a question in the Q&A that kind of I'm going to merge together a little bit. But my question was, why isn't Congress stepping in to check the executive, besides the obvious answer that it's controlled by the same political party? The question we got in the Q&A is there a viable method for Congress to claw back the powers, that they've ceded to the executive branch in some instances here?
It's a great question. Both of them are great questions. So in terms of viable ways to claw back power, Congress can do what it wants here. It can try to pass new legislation rather than relying on presidential executive orders and just going along with them just because many of them, Republicans in Congress right now, agree with them. But at the same time, you need a president to sign legislation, and then you have to go down the route of overriding a president's veto, which is very difficult to do and not likely to happen with a party that's in the same party as Congress that's in the same party as the president. In terms of why Congress isn't standing up for themselves, with probably a lot of folks in here recall from high school or college sort of separation of powers 101, right? That part of the reason the founders, separated these branches of government is because they assumed, right, that they would be competitive with each other. And they assumed that, members of Congress, for example, would want power, as humans tend to do. And that the way you would get power is by challenging the other branches and trying to sort of establish branch supremacy in a certain way. But over the past 50 or 60 years, we have seen some pretty significant trends kind of away from separation of powers and towards a kind of separation of parties, that because the parties have become so polarized, so different from each other, members are motivated by different things, and they are not motivated to separate themselves from a president of their own party. So, for example, in this past election, only about a dozen or so members of Congress were elected in districts that supported the other party's presidential candidate, right? So these would be Republican members of Congress elected in districts that Kamala Harris won, or Democrats elected in districts that Trump won. Past few elections, there have only been, about a dozen each time. Whereas back in the 1960s, 70s, and even 80s, you had hundreds of districts that fell into this category. You had Reagan Democrats, right? And you had Republicans elected all in a bunch of Lyndon Johnson won districts, right? And thinking through, like, what does that do to the incentives of a member of Congress? And what it means is that as Americans are ticket splitting less, meaning they're not writing it, they're not electing a Democrat for president, but then choosing a Republican congressional candidate. They're pretty much going straight down the line for one party or the other. And what members interpret that as is, well, if the president is in my party, I'd better support them because that's the message I'm getting from voters, that my sort of political and electoral fate is more tied to the president than it was, 50, 60, 70 years ago. And if you've got a president of the other party, then what are you motivated to do? Well, you're motivated to sort of fight them at every possible instance, as Democrats did during the first Trump administration after they took back the House, certainly as Republicans did with President Biden after they took back the House in 2022. And that, I mean, the ads we see in political campaigns are reflective of this, that members, regular Americans don't actually know a ton about their individual members of Congress, which is tragic for me, but it's the way it is. But they do tend to know a lot more about presidents. And so these ads we see will say, so-and-so voted with Donald Trump 95 or 100% of the time. And depending on which party they're in, that's either the best compliment in the world or it's completely disqualifying, right? And so that is, I think, the big kind of political motivation that has changed a lot over the past 50 years. And that helps explain a lot, I think, of why Republicans right now are feeling like they need to just support Donald Trump at every turn, because then the next election is going to come around and they're more worried about a primary challenge in their own party than they are about a general election candidate. Because what we've also seen over the past 50 or so years is fewer and fewer competitive congressional districts, fewer and fewer competitive states. More and more parts of the country are really safe for Democrats or really safe for Republicans, and it did not always used to be that way. And so that's setting up these electoral incentives for members of Congress.
Yeah, thank you. And my organization works on trying to solve some of these problems through fighting gerrymandering and other issues. Lynette, one of the things we heard from Professor Hassel is like kind of the damage has already been done in some instances. The question I had for you is like, what tools do the courts have to enforce their rulings when they decide that they're in violation of the statute or in violation of the Constitution? It seems like the Trump administration has been ignoring some of those rulings. And I wonder if you could speak to that.
Well, the courts don't have an army, and they don't appropriate money or withhold money. So if there's total defiance, then we have a breakdown of our democratic norms. This wouldn't be the first time that's ever happened, so I think people should be aware of that. The classic one was back in Andrew Jackson, which was Worcester versus Georgia, when the Supreme Court ruled that the Cherokee Nation had tribal rights in Georgia, and the president ignored those declarations, and they were forcibly moved from the state. And it's one of many, bad moments of our history. the Trump administration has said many times that they will not defy court orders. So they so far have not openly defied the US Supreme Court, as far as I know. They do a lot of wordsmithing, and they invoke either with sincerity or guile the notion of national security. I mean, that's I remember back to the Nixon days and Watergate, when national security was was invoked many times to try to hide what was happening at that point. But that is often invoked, and there are areas in terms of like the armed forces, immigration, where the presidential power is much broader than in other areas in terms of enforcing congressional enactments that don't involve that. So you've seen some differences with what the courts have done in terms of the presidential proclamation that they're going to eliminate transgender individuals from the military. The Supreme Court refused to stay that. And that happened, I think, in the first Trump administration as well. And so there's a lot of deference in the area of the military, and a lot of deference in the area of national security and immigration. But in terms of open defiance, I have not seen open defiance of an order of the US Supreme Court at this point. There's certainly been a lot of trashing of lower courts, and they've been ad hominem. It's personal attacks on the judge, as opposed to just saying these decisions are not well reasoned. And so I can't tell you whether it's coming or not, but I don't believe it's here yet. And of course, that's why we fight every day in the courts.
Yeah, I think that's a good transition to Miriam, that you were at the Rhode Island Attorney General's office for 4 years. It seems like attorney general are sort of at the forefront of a lot of this litigation. Can you speak to why that is? And then, Lynette mentioned judges getting trashed. One of our own judges in Rhode Island has been, federal judges has been involved in some of this litigation and has been dragged through the mud. If you could speak to why maybe things are being filed in Rhode Island.
Yeah. So, so as to why state attorneys general are involved, it really has to do, I think, with three things. One is, what is their mission? The other is they have a right to be in court that's broader than the regular person, what's called standing, and they have resources. So, it's the mission of the Office of an Attorney General to protect the public and to enforce the law. And so when the executive does what they're doing here, which is just come in and say, stop funding a state agency, because even though the law says, Congress voted and said, we want to do, whatever, we want to do lead remediation, we want to do, food for children, and we're appropriating this money, then it's a law. And when the executive comes in and just breaks the law, the attorney general can go to court and has an obligation to, because it's their job to protect the public. So I think that's one reason, that's why you see attorneys general. The other reason is, as I said, standing. So you can go to court when you've had the injury. If you're mad because somebody else was hurt, you're not the one who can go to court, right? But attorneys general have a broader right because they have the obligation to protect the public. So that's another reason you see them. And then they have resources. They, having led the civil division here in Rhode Island, we have lawyers who have expertise in a number of different areas. We built out the consumer division. We've built out, we built out the environmental the environmental unit, we built out the healthcare unit. So now, and the civil rights unit. So now we have all of that expertise, and also a deeper expertise than most in just sort of constitutional questions, which is in what we call the Solicitor General. So that's why attorneys general are you see them so much, and there's such a critical part of this. And you know, they have the capacity to bring these big suits, unlike the Lawyers Committee for Rhode Island. You know, this illegality is just, it goes everywhere like water, right? And we're very grateful for the attorneys general and the ACLU and other organizations bringing these big suits, but still it leaves many, many, many other people unprotected. So you really need both. As to why cases are being brought here in Rhode Island, you know, first of all, this is a court without a lot of wild cards. They're, in my opinion, these judges are consistently fair. I don't always agree with them, but they're consistently fair. They're consistently faithful to the Constitution. Again, you know, we can have disagreements, but you don't really have a wild card where a judge just, you know, has such an entrenched personal opinion that you can't expect the law to be upheld. And, you know, they reflect in general, the politics of the state, which are, I would say, in general, are more sort of humanitarian than many other states. So so it's a good place to bring litigation. And then if a case is appealed from this district court, you know, our trial court, it goes up to the First Circuit, which is the appellate level before the Supreme Court when you're in the federal system. And the First Circuit also is more fair than other parts of the country. So so those are the reasons.
Thank you. Yeah, we're getting a couple of versions sort of the same question, which is, and you touched on it, that attorneys general have sort of broad authority, broad standing, but like people are asking, you know, can an everyday person challenge? And I don't know, you or Lynette, you know, in the case you've brought, Lynette, like talk about the challenge of having individuals challenge the executive orders.
Well, you need to have, as Miriam said, it's called standing, and standing requires an identifiable injury. It doesn't have to have already occurred, but it has to be something that's sufficiently immediate that it will occur to you. If you disagree with a particular policy, but it's not impacting you in a direct kind of way, then you don't have the standing to challenge it. There are some states, sometimes in Rhode Island, when the state courts will hear a kind of like a citizen attack, but of a particular rule. But the federal court system requires that you have standing. They don't issue what's called advisory opinions. So in order to be heard, and because these are all executive orders, proclamations, or something that the federal government acted on, you cannot. You could try to sue the federal official in state court, but there's a vehicle that immediately moves them right into federal court. So you have to satisfy the concept of standing, which requires a recognizable injury, and that what you're seeking as a result would actually redress or correct that injury. So generally speaking, an individual who's upset, and as many of us are, it doesn't have standing to challenge it.
You know, to the extent that that question's being asked because people are wondering, you know, what can I do, right? I will say that organizations, let's take organizations that receive federal funding or applying for federal funding, they, in general, have standing. And so I would imagine that a lot of people who are watching this are quite civic-minded and may be involved with nonprofits. And helping nonprofits understand when there is a basis to challenge action by the administration, and just, you know, educating yourself helping to educate the board of the nonprofit. Please feel free to turn to us as a resource. That's one thing that we do is educate nonprofits so they understand you actually have a right to challenge this illegality. So that, I would urge people to recognize that you have a really, really important voice if you're involved with a nonprofit, even as a donor, if you're involved.
That's a great point, because I think, yeah, many people who probably sit on boards of nonprofits in Rhode Island, donate to various nonprofits in Rhode Island who can, yeah, raise the fact that you have stood up this organization to help them. We're racing against the clock. Unfortunately, I always write more questions than I can ask. I'm going to try to combine two questions for Professor Hassel here, which is, I wanted to kind of get at this idea of a unitary executive theory. There is kind of a theory behind what Trump is doing, and oftentimes referred to as the unitary executive theory. And it seems to be somewhat successful at convincing the Supreme Court that this is an actual theory and they should, follow it and support his position on it. And just last week, they sort of on something called the shadow docket, looks like they maybe overturned a case called Humphrey's Executor, which goes back to the New Deal. And so could you just speak a little to the unitary executive theory and what might be happening here?
Sure. So the unitary executive theory has been around for probably at least a few decades, if not longer. It's a conservative, a conservative political theory, legal theory about what's the scope of the president's executive power. Because there is only one president and he's one person, this theory is that the entire authority of the executive branch has to be is located in that one person, so that there can be no limits on the president's ability to control the entire executive branch. And the origins of this probably go back to the New Deal, where independent regulatory agencies were created, such as the National Labor Relations Board or the FCC or the Federal Trade Commission. And there are commissioners in these organizations who cannot be totally controlled by the executive branch. They have some independence. Congress set up these agencies so that these particular independent regulatory agency would have some ability not to be completely politically controlled. There are limits, they have term limits, there are limits on how they can be fired. And so Congress set up these semi-independent agencies within the executive branch, and the president can't control them entirely. And so under the unitary executive theory, this is a problem. The president ought to be able to control every single thing, what the Federal Reserve does, what the FCC does, he should be able to control the members of and the actions of all of those. Congress has decided, beginning after the New Deal, that there should be some ability for some independence, some expertise, some nonpartisan ability to run these agencies. And that's what the unitary executive power is running into. Let's get rid of these independent regulatory agencies, part of the larger project of dismantling the administrative regulatory state and having less and less independence, authority of this large administrative state, which some people feel is inappropriate, should be more democratically controlled by the president who was elected. So every 4 years, we could have a different interest rate, a different, all these things could be controlled by the president. The fact that Congress can give these agencies some independence was decided in this case called Humphrey's Executor in 1935. Congress put in these limitations on these agencies, created these agencies. Roosevelt didn't like it. He wanted total control. And the court said, no, it's within Congress's authority to put some limits on your power, even within the executive branch. And that has been a precedent for 90 years. It has recently been challenged. The president has fired members of I think the National Labor Relations Board and the Merit Systems Protection Board, contrary to the statutes which say he cannot fire them without cause. He did it anyway. And so they challenged that. And using the emergency docket or the shadow docket, the Supreme Court has said, well, we think that there's real harm to the president in not being able to fire these people, and so he can. This was through an emergency order, through a stay on a lower court opinion. It was not fully briefed. It was not fully argued. It wasn't argued at all. Well, I guess it was briefly, but not the full merits document kind of treatment. That's a critique of the shadow docket, which I'll leave for another moment. But that decision, that emergency decision on the shadow docket, seems to make it very clear when they get to the merits of these firings, the Supreme Court will overrule Humphrey's executor, that 90-year precedent that has enabled us to have independent agencies. The one limitation they seem to put in their opinion is we're not going to do this to the Federal Reserve. There seems to be, okay, we have to have independent monetary policy. Why we should have independent monetary policy, but not independent other kind of policy, not clear. But it seems like for most agencies, any limitation on presidential control will be eliminated. This has been a long fought for and long wanted sort of imposition of a constitutional theory that it looks like with the current Supreme Court is going to win the day.
Yeah, thank you. And I apologize. I wrote a lot of other questions that we're not going to get to. I know we had questions in the chat we didn't get to, so I will direct the panelists. If you see any questions in the chat that are very specific and you want to try to answer them, you can do that in the Q&A there. Sorry, not the chat, in the Q&A. You can type and answer there. But to honor everybody's time, I just want to transition us to the end of the program tonight. One of the questions we got at the when people registered is, do governors have this power? And actually, yes, governors have executive power that is similar, and it's also similarly kind of bounded by the courts in Rhode Island. I'm going to ask Alicia to put in the chat a link, or I can, to all the executive orders issued by the current governor as well as his predecessor. So you can see there are many. But I'm going to hand it over. I'm going to just start wrapping it up here. I want to thank the panelists and apologize I didn't get to all the questions, but I want to thank you for joining, sharing your expertise, sharing your experience. Thank you for your work, those of you who are in the trenches fighting this. I want to thank the ACLU again for co-sponsoring and for their work fighting against illegal executive action. I want to thank you, the audience, for showing up on a nice June evening. And I'm going to thank Alicia for helping organize and run the webinar. And I'm going to hand it off to her. She's briefly going to give you a couple of calls to action.
Thank you so much, John. Yes, and thank you to our incredible panelists and to Patty, our interpreter. There's a lot going on right now, and if you are ready to step in, take this information you've learned about and get ready to act and protect our democracy, then please fill out the form I just put in the chat. Join the Common Cause Rhode Island Action Team. That is our volunteer list where we will be sending information to on opportunities to directly take action. I've also shared the ACLU of Rhode Island's educational materials on knowing your rights. They have a huge collection of information that touches on a lot of things that communities need right now. So yes, and as John put in the chat, the link to the executive orders. So I will be sending a follow-up email to everyone tomorrow that will include all the links that were shared in the chat. Just thank you again so much for your time, for being with us on this Wednesday evening, and we hope you have a great rest of your night. Thank you so much.